Welcome to today's program titled Guidance on State and Local Paid Sick Leave Laws, Part 6, Navigating New York State Paid Sick Leave Mandates in 2022. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. At this time, I would like to turn it over to our first speaker for today's program, Josh Seidman. Josh, please go ahead.
Great. Thanks so much, Kate. Hi, everyone. Good morning and good afternoon to those of you on the East Coast. Kate, if you could go back one slide for us. Perfect. So thanks, everyone. Happy 2022. This is part 6 of our Guidance on Paid Sick Leave Laws webinar series, but the first of our 2022 webinars. So welcome. Hope everyone is doing well. Happy belated New Year. And we're really excited for you all to be joining us today. We have an incredibly hot topic to be diving into, and that is the world of New York paid leave, both COVID and non-COVID. There's been a lot of developments in this space since part 1 of this webinar series, which focused on New York developments. That was back in the fall of 2020. So a lot has happened in the last 12, 13 months or so. And we have a lot of topics to dive into and share with you, both in terms of overviews as well as substantive updates. I'm being joined today by my colleagues and friends, Marlon Duro and Michelle Shamulian. I'm Joshua Seidman, again, all based out of our New York office, and very happy to be here with you today. As you'll see on our next slide, we have an agenda that will take us first through the nationwide paid sick leave landscape, give you a very brief overview about what is in store at the state and local levels across the country. We'll then turn our attention to the New York State level, but still fairly broad, give you an overview of different leave laws at the state and local levels in New York. And then we'll dive into the meat of today's presentation, which includes topic number 3, an overview of the New York State non-COVID general paid sick leave law and the recently released final regulations, as well as the State Department of Labor's commentary on those final regulations. We'll then turn to COVID paid leave, both emergency COVID paid leave, number 4, and then vaccine paid leave in number 5. And we'll round out today's discussion with a focus on amendments to the New York City Earned Safe and Sick Time Act. So without further ado, let's get into the substance with our nationwide paid sick leave overview. As you'll see on the next slide here, there are a lot of paid sick leave laws around the country, COVID and non-COVID. If you've been with us for prior parts of our webinar series, this slide will look familiar to you. However, we continue to update this roadmap of paid leave as there are different developments at the state and local levels. So today, as of February 1st, a couple of days ago, there were a total of 65 paid sick leave and paid time off mandates in the U.S. Now, paid time off is not paid family leave, not paid jury duty leave or things like that. That is focused on sort of paid personal time off mandates. That number has ebbed and flowed, continues to ebb and flow, has both before COVID and certainly throughout the COVID pandemic, as new laws have been introduced, prior laws have sunset or been preempted, temporary laws have come and gone. And because of that number, as you can see at the bottom of that leftmost column, in December of 2020, there were a total of 69 of these mandates, right? The number hit the low 70s throughout 2021 and has now dipped back into the mid-60s as of today, in the February 2022. Looking at the next column, the federal column, give a shout out to Executive Order 13706, paid sick leave for employees of certain federal contractors and subcontractors, been around since the Obama era. Shout out also to the Families First Coronavirus Response Act. The FFCRA was around providing federal emergency COVID paid leave for a good portion of 2020, but only for certain sized employers, and that ended at the end of 2020. And even reimbursement for employers that were voluntarily providing those benefits ended at the end of September of last year. At the state level, we have 17 states plus Washington, D.C. Obviously, we'll be focusing today on New York State and all the goings on there. There have been some big developments in other jurisdictions as well over the last year or so. Washington, D.C., Massachusetts, with respect to their emergency paid leaves, COVID paid leaves. Colorado just underwent some major amendments to its wage protection regulations that have a big impact on paid sick leave. And we have 2 PTO laws in Maine and Nevada that are worth being aware of. Both are currently in effect. At the municipal level, there are 28 different locations, different jurisdictions that have at least one paid sick leave or COVID paid leave mandate. Again, many big cities, major cities, as well as some smaller cities and counties as well. Allegheny County, Bernalillo County, Westchester County here in New York, among others. As you can sort of see, if you're doing the quick math, you add up the one federal law, 17 states, Washington, D.C., and the other 28 municipalities, that number does not add up to 65. And the reason, not a trick answer, is on that first leftmost column, it's because multiple jurisdictions have multiple of these mandates. New York, perfect example. Today you'll be hearing about 3 different statewide paid sick leave mandates and 2 different New York City paid sick leave mandates, right? That factor into that 65 number total. One final point before I move off this slide, California supplemental paid sick leave. For those of you who have been keeping track at home, there yesterday, just as hot off the presses, the state released its legislation. So not yet enacted, it has not yet been passed, but there is now legislation that has been formally released to the public about 2022 California statewide supplemental paid sick leave mandate. So if you remember, there was a 2020 version of this mandate. There was a 2021 version of this mandate. The most recent one ended in September, September 30th of last year. It does look like California will be having a supplemental COVID paid sick leave mandate coming in short order over the next few weeks. So be on the lookout for that. We'll keep all of you up to speed. Next slide, please. This is a slide that we'd like to include with our presentations. It's a map as of January 2021, so that a year ago, of what the paid sick leave landscape looked like. COVID laws, non-COVID laws, anti-local leave laws, where states pass laws that prohibit localities from enacting their own paid sick leave mandates, essentially saying sick leave has to come from the state. And there have been developments since this was rolled out in the beginning of 2021. There's a new mandate in Virginia that only applies to home health workers, but that went into effect last year. New Mexico now has a statewide law that's coming down the pipe, goes into effect in a few months in July. New mandates in Allegheny County, Pennsylvania, West Hollywood, California. And many COVID laws have come and gone. So we'll be rolling out an updated version of this interactive map later this year. But for those of you who are interested in what's been happening with paid sick leave from before 2014 through 2020, the end of 2020, this is a great resource for you. Next slide, please. So with that, I'm going to pass the baton over to Marlon Duro to start talking us through the New York paid leave law overview.
Thanks very much, Josh. Now with that nationwide perspective, we will look at the New York leave laws. Now these are only a selection of laws, and they fall into 3 different categories. We have some paid sick leave laws, the paid family leave law, as well as some benefit laws. In the paid sick leave category, we have the New York statewide paid sick leave law, which gives employees 40 or 56 hours of paid or unpaid leave, depending on the employer size. We will go into more detail in this in a little bit. The next paid sick leave law we have in New York is the New York statewide COVID-19 emergency leave law, which provides paid sick leave and or paid family leave in varying amounts and types based on employer size. Josh will cover this in more detail in a little bit. And then next up, we have the third New York paid sick leave law, which is a COVID-19 vaccine leave law, providing 4 hours of leave per COVID-19 vaccine injection, but I will let Michelle go into the details of this later. In the paid family leave section, we have the New York Paid Family Leave Law that provides employees with up to 12 weeks of paid leave for eligible employees to use for covered reasons, including to bond with a new child or to care for a family member with a serious health condition. Now, there's been a number of updates in regards to paid family leave, but because this webinar has a paid sick leave focus, we will not be going into all of those details. The one significant update that I do want to note, however, is that starting January 1st, 2023, a sibling will be a covered family member under the PFL law. Moving on to the benefit laws, we have the New York Disability Benefit Law that provides temporary cash benefits to employees if they're disabled by an off-the-job injury or illness. If the injury or illness is a direct result of the employee's job, however, then New York workers' compensation would apply to provide the employee cash benefits or medical care. And then finally, we have the New York Unemployment Law, which, as you all may know, just provides employees with temporary income when they lose their jobs through no fault of their own. As I mentioned, this is not all the leave laws in New York. There are many other leave laws, including the crime victim, witness leave, blood donation leave, bone marrow leave, domestic violence and sexual assault leave, voting leave, emergency responder leave, and family and military leave, just to name some of them. And now that we got that New York overview done, we're going to look at the local laws in New York. So we're going to have a focus on New York City and Westchester County specifically. In New York City, we have the New York City Earned Safe and Sick Time Act, where employees are permitted to accrue and use either 40 or 56 hours of paid leave, depending on employer size. Michelle will be giving us some more details on that later in this presentation. And after that, I will be talking to you about the most recent amendment to the New York City ESTA, which is the addition of the child vaccine leave, providing up to 4 hours of leave per COVID-19 vaccine injection per child. But I'll get into the rest of the details of that in a little bit. Now, one law that's not talked about very much, but that is out there and that you should be aware of, is the New York City Temporary Schedule Change Law. Employees are entitled to temporary changes to their work schedule for certain personal events. And then from New York City, moving to Westchester County, we have a leave law there. We used to have two. However, the Westchester County Sick Time Act is no longer in effect. It was preempted by the New York State Paid Sick Leave Law when that was passed and went into effect on September 30th, 2020. Although the New York State law has the safe leave component, the safe leave law in Westchester County was not impacted by that. In fact, that's still in existence, and employees are entitled up to 40 hours of leave for certain safe time absences in New Jersey, in Westchester County, I'm sorry. And this is in addition to any leave that the employees are receiving under the New York State Paid Sick Leave Law. Okay, so with that, now we have a good idea of the landscape of sick leave laws at the national, at the state, as well as at the local level. So it's time to dive in and discuss the details of the New York State Paid Sick Leave Law and some recent updates to that law. So as you'll see on the next slide, the effective date of the law was September 30th, 2020. The law applies the very broad coverage standard, employer coverage standard of the New York labor law, as well as the broad definition of New York labor law's definition for employee. So essentially, it covers all private employers and all employees working in New York State. So there is no size requirement for an employer in order to be covered, but as you'll see, the employer size does matter in terms of the accrual cap and the usage cap. So under the New York State sick leave law, employees can accrue leave at the rate of 1 hour for every 30 hours worked, and this begins at the start of employment. Employees can use and accrue up to either 40 or 56 hours of paid or unpaid leave depending on the employer size. So more specifically, employers with 4 or fewer employees in any calendar year have to provide employees with 40 hours of unpaid sick leave in each calendar year. There is an exception to this. For those employers that have 4 or fewer employees, but that have a greater than $1 million net income in the previous tax year, then those employers have to provide 40 hours of paid sick leave. So it's not unpaid, it's paid. And that is the same amount of leave that employers with between 5 and 99 employees in any calendar year have to give. Employers with 100 or more employees in a calendar year have to provide 56 hours of paid sick leave in each calendar year. In terms of usage cap, again, that depends based on the employer size. So it could be 40 or 56 hours paid or unpaid depending on the employer size. Now, how do we determine employer size? So unfortunately, the law did not address this, but the good news is that we now have some guidance from the Department of Labor regarding how to figure that out, but I will talk about that in a little bit. One important thing about the New York law and is the usage waiting period, the fact that it has no waiting period. So New York is not the only place to have no waiting period for new hires, meaning that they can use it as soon as they accrue or the leave becomes available through front loading. New York is not the only one, but it's one of very few jurisdictions to do that. So that's important to keep in mind. In terms of carryover, there's no carryover cap in New York, which means you have to permit employees to carry over time from year to year without any limits on that. Front loading is permitted. However, the law is unclear on whether front loading gets rid of carryover obligations. The good news is that the regulations and guidance released by DOL gives us an answer regarding that, and we will discuss that shortly. But before we get to the DOL guidance, I do want to remind you of the reasons for use. Under the New York State paid sick leave law, the employee can use leave in order to take care of themselves or a family member who has a mental or physical illness, injury, or health condition. This is regardless of whether that condition has been diagnosed or requires medical care. Employees can also use leave in connection with a diagnosis, treatment, or preventative care for themselves or a covered family member. Employees can also use leave in connection with safe time absences, which are absences from work due to either the employee or a covered family member being the victim of domestic violence, a family offense, a sexual offense, stalking, or human trafficking. New York State includes the following members as covered family members. They include a child, a spouse, domestic partner, parent, sibling, grandchild, grandparent, and the child or parent of the employee's spouse or domestic partner. And the reason that I point this out is because for those of you familiar with some of the recently enacted or recently amended paid sick leave laws, most of those laws include a catch-all family member, including basically anyone that the employee is related to by blood or that the employee has such a close relationship that they're considered a family member. New York State does not have this as a covered family member. However, pay attention in the New York City piece because you will see that New York City has a catch-all family member. But Michelle will give you more details on that later in this presentation. So just like other paid sick leave laws, the New York State law comes with a number of different requirements and obligations, including increments of use, available balance notice, record keeping, and many other requirements. I'm not going to go into detail in all of the, in regards to all of those, but I do want to I want you to pay attention to the written policy requirements, which you see on this slide. So although the New York State paid sick leave law itself does not contain a written policy provision, the New York labor law does have such a provision and requires employers to notify employees in writing or by publicly posting the employer's policy on sick leave, vacation, personal leave, holidays, and hours. And the New York State paid sick leave website also states that employers do in fact need to have such a writing either posted or given to employees. So be sure to have a written policy that's compliant with New York State law. And with that, we'll move on to the next slide, where we're finally going to talk about the final regulations. So New York State released their proposed regulations in December of 2020, and then they just kind of went quiet and didn't release any final regulations for a while. They didn't give any information about when they were going to be released. And then finally, December 22nd, 2021, New York State gave us the final regulations. Now, in this slide and the next slide, I'm going to talk about two things. I'm going to talk about the final regulations, which are the binding regulations that New York State released. But along with these regulations, the Department of Labor responded to some comments that they had received during the rulemaking period. And while those are not binding the same way that the regulations are, they're very helpful because they tell us information about how the DOL is interpreting the law and what to expect for them if there's an audit about how they're going to treat the law. But first, I'll start with the final regulations themselves. So these are just some of the highlights. This is not every topic that was covered, but these are some very significant updates. So for example, the regulations set up an accrual increment system. So unlike some paid sick leave laws, which permit employers to provide paid sick leave accrual in 1 hour increments, the New York City regulations provide that paid sick leave accruals must account for all time worked, regardless of whether the time worked is less than 30 hours. So although the accrual rate is 1 hour for every 30 hours worked, when calculating accruals for time worked in an increment of less than 30 hours, employers may round the accrued leave to the nearest 5 minutes, 1/10 of an hour, which is 6 minutes, or 1/4 of an hour, so long as over a period of time, an employee will still be provided with a proper accrual of leave for all the time that the employee has actually worked. So in those jurisdictions that have the 1 hour increments of accrual, employees accrue 1 hour of leave after they have worked 30 hours. So they work 30 hours, they earn 1 hour of leave. They work the next set of 30 hours, they get the second hour of leave, and so on. But New York State regulations are saying we're not going to do that. We want you to account for all the time that the employee has worked, and you need to give them leave for portions of time worked. So for example, if the employee has worked 7.5 hours, you don't wait until they work 30 to give them 1 hour of sick leave. After working 7.5 hours, the employee has accrued 15 minutes of sick leave. After they worked 15 hours, they've accrued half an hour of sick leave, and so on. Now, this is complicated, but it becomes even more complicated when you factor in increments of use. And because of how complicated this is, it would require too much time to go into specific detail in this webinar. But just note that employers should be taking a closer look at the systems that track accrual, as well as policies in regards to increments of use, and determine from a legal as well as a practical perspective what would make sense. Another important topic addressed in the final regulations is employer size. So the final regulations tell us that the employer should count the highest total number of employees that are currently employed at any time during the calendar year to date. Although the regulations don't provide this, the DOL comments preceding the regulations tell us that employers should be counting all employees nationwide in determining whether they trigger the 40-hour or 56-hour of leave requirement. So that's an important thing to note. So for those who are taking a wait-and-see approach here to see what the guidance would say, we are counting employees nationwide, so be sure to update your policies and provide the correct amount of leave to employees. One other important update in the final regulations is in regard to documentation. So the regulations let us know that employees have to use leave for 3 or more consecutive and previously scheduled workdays or shifts in order for an employer to be able to request documentation. So if the employee only uses leave for 1 day or 2 days, you cannot require documentation. If you are requiring documentation after the employee has worked 3 or more consecutive and previously scheduled workdays, you have to be mindful that you cannot ask the employee to disclose confidential information or to pay associated costs or fees. So if the employee is required to pay costs or fees to get that documentation, the employer will have to cover those costs and fees. Finally, the New York State regulations set a very limited scope of what's considered appropriate documentation, and they limit it to either an attestation from a licensed medical provider or an attestation from the employee saying that the employee is eligible for leave. The DOL did say that they will publish a template for employee attestation. So what's missing here in terms of documentation is in a lot of the laws that have safe time leave as a reason for use, they generally provide us with examples of reasonable documentation that could be requested in order to show that the employee was permitted to take leave for a safe time reason. So those often include like a note from a clergy member or from the district attorney's office. The New York State law is silent and does not have any types of documentations that are specific to safe time. And with that, we will move on to the next slide where I will be discussing some of the DOL commentary, which, as I said, is not binding. However, it is still important and lets us know how the DOL is looking at these issues. So carryover was a hot topic with New York State because there was no cap for carryover on in the law itself. So what the DOL comments let us know is that employers cannot implement a use it or lose it option. Whether you're front loading or accruing the time, you have to let employees carry over time. And there's no cap on that. You have to let them carry over all time to the next year. We also got some helpful information regarding to cash out at year end. So employers have 2 options. They can either give employees the option to, 1, voluntarily elect to use and receive payment for paid sick leave prior to the end of the calendar year, or alternatively, the employee can choose to carry over unused sick leave. Whether the first option means that you could provide cash out is not entirely clear. It's a little bit of a gray area. The other option employers have is to just permit carryover. In that case, employees don't have any option about, they don't have a choice. The employer would just make the determination to permit carryover. In terms of notice to employer, the DOL refused to make a distinction between the type of notice provided for foreseeable and unforeseeable absences. They said that there's a gray area in regards to what's considered foreseeable versus unforeseeable. They also refused to make a notice and posting requirement for employers, so the good news is you don't have to worry about posting a notice. However, be mindful of the written policy requirements I mentioned earlier. And then finally, in terms of rate of pay, I wanted to note that the law provides employees must receive compensation at their regular rate of pay. Or the minimum wage if that's higher. But the DOL was asked to give some guidance on what regular rate of pay means. However, they refused to do so. They said there's plenty of information on that. There's case law, there's other guidance under the labor law, so we're not going to do that here. They did say, however, that an employer's failure to provide an employee with sick leave benefits is tantamount to a failure to pay an employee his wages. And the thing to remember here is that there are penalties for failure to pay wages, including payment of unpaid wages, liquid damages, and civil penalties. This is especially important because we've seen an increase in litigation for failure to pay wages in regards to sick leave, especially in California. So we may see this increasingly in New York as well. And with that, I will turn it over to Josh.
Great, thank you so much, Marlon. Hi again, everyone. We are now going to turn to the second of the New York State paid sick leave laws, and that is the COVID-19 emergency leave law. Next slide, please. Even though this law has been around since the start of the pandemic, or the first few weeks of the pandemic, since March of 2020, it's still giving employers some headaches, still presenting some challenges, both in terms of understanding the requirements, the overlapping interplay with guidance from the State Department of Labor, State Department of Health. We'll talk about both of those over the next few slides, and then administering the benefit on the ground. So to kick things off right from the get-go, number one, you can see the amount of leave as well as the type of leave for COVID emergency leave will vary based on both employer size as well as, in certain circumstances, employer income. For purposes of everyone kind of on this call, we're going to focus on this webinar. We're going to focus on the bottom group, that 100 or more employees category, based on what Marlon went over and the updated guidance from the State Department of Labor with respect to the non-COVID paid sick leave law. And I know a few folks had questions about that, how you determine employer size. Is it determined based on your national workforce headcount or your New York State workforce headcount? Because the non-COVID sick leave law is focused on at the nationwide headcount, we believe that would be the same for purposes of emergency leave under this law, under this mandate as well. So looking at that group, right, that 100 or more employees number, employers are required to provide at least 14 calendar days of emergency paid sick leave to their employees. Now, while not clear necessarily under the law itself, it does appear that additional COVID emergency paid family leave benefits are available to employees of this size employer to care for their dependent child who is subject to a covered order of quarantine or isolation due to COVID-19. So in thinking about this benefit, a couple of points to note. Number one, I saw a question come in from one of our attendees. There is no sunset date for emergency COVID paid sick leave. There are sunset dates for pretty much every other state and local COVID paid leave law around the country, but not in New York, not with this one at least. So that is worth keeping in mind for sure. Number two, broad application to private employers, broad application to employees, covers full-time, part-time, temporary employees. Employees would not be eligible for these benefits to the extent they are not showing symptoms and not physically able to work. That includes, not able to work remotely. That's based on an FAQ that the state has released. I mentioned a note in that third bullet point here that the 14 days are measured as calendar days. That's not work days, that's calendar days. And that's an important point that was clarified from the State Department of Labor FAQs. And they specifically noted that you determine the amount of emergency paid sick leave an employee is entitled to based on what they would have been paid had they continued to work during that period that they were subject to an order of quarantine or isolation. In addition, and importantly, the emergency COVID paid sick leave does not run concurrently with New York State regular paid sick leave, right, or other accruals for that matter. The law and the FAQs both come out and expressly say that in terms of coordination with employer policies, the New York emergency paid sick leave does not run together, right? It's above and beyond, and you cannot count existing accruals, paid sick leave or other paid time off, towards this New York emergency paid sick leave obligation. So there was a question that just came in on that point, so that's the answer to that one. Next slide, please. So as you'll see on this next slide, New York emergency COVID paid sick leave is available to employees for really one narrow reason. And I say narrow because if you think about other emergency paid leave laws around the country, the one that is pending for California, Massachusetts, Washington, D.C., Colorado, Nevada, and the like, they typically have broader scopes of covered COVID-related absences than just being subject to a mandatory or precautionary order of quarantine or isolation issued by the state of New York, Department of Health, local board of health, or other government entity due to COVID-19. They usually will cover things like closures, school-related closures, workplace closures, caring for family members who have symptoms or test positive, perhaps, vaccination-related coverages as well, although New York does have a standalone vaccine paid leave law that Michelle will cover in just a few minutes. Also, as I mentioned on the last slide, there is this expanded paid family leave concept, this COVID paid family leave under this emergency leave law. That leave is available to provide care to an employee's minor dependent child who is subject to one of those orders of quarantine or isolation due to COVID issued by the appropriate entity. Now, importantly, and different from the emergency paid sick leave portion of this law, the emergency paid family leave portion does not expand, is not above and beyond the standard 12 weeks of paid family leave under the regular New York paid family leave law. So if an employee has a covered COVID need for emergency paid family leave here, that would draw down their general 12 weeks of paid leave, paid family leave, that is. There's a form, a specific application form for COVID paid family leave on the state's paid family leave website. And keep in mind, too, that even though the emergency paid family leave is limited to a dependent child, paid family leave generally is available for employees to care for other family members, not just their child, who have a serious health condition, parents and spouses and the like. If one of those other covered family members are diagnosed with COVID and that is considered a serious health condition, then regular paid family leave would be available to the employee if they need time off to care for that individual. Now that assumes that the employee would otherwise be eligible under the eligibility criteria of the paid family leave law. Although the scope of covered absences for emergency paid sick leave is narrow, especially compared to other COVID leave laws, the nature of what is considered a quarantine, what is considered isolation, when those are triggered, the concept of obtaining an order, in practice, those have been moving targets and have been evolving and changing as the pandemic has evolved and changed. And some of the recent updates, as recent as last month on those topics, have had a practical impact on administration of New York COVID emergency paid sick leave that we'll be discussing over the next few slides. Next slide, please. In January of last year, the New York State Department of Labor released some guidance on the emergency paid leave law with respect to emergency paid sick leave. I'm not going to go into all the details of that guidance, but a couple of highlights are important to note here because they impact administering this benefit in 2022. Number one, there is a maximum number of orders that emergency paid sick leave can be triggered from. It's not just a single order of quarantine or isolation, but instead it is a maximum of 3 orders of quarantine or isolation that can trigger emergency paid sick leave. But there are some limits because it's only available in certain situations. Most notably, that emergency paid sick leave for the first order of quarantine or isolation can be available to an employee if they test positive for COVID, which the Department of Labor guidance from January 21 says is automatically triggering an order of isolation. And that first order, right, that emergency sick leave with respect to order number 1 can also be triggered based on the employee's close contact with an individual who has COVID or is suspected of having COVID. But the second and third orders, that would trigger additional emergency paid sick leave, that emergency sick leave is only triggered if the employee tests positive. Now that can be for COVID. So that can be testing positive immediately after the initial order ends, right? They just continue to test positive, or they have recovered from that initial positive diagnosis, they're back at work, and sometime down the road, they test positive for COVID-19 again. So that is the setup for the multiple orders and when they are available to employees. Now, as you'll see on the next slide, the January 2021 DOL guidance is also significant for a second big reason, and that is it added this pay continuation requirement for employers to pay attention to that is separate from but interrelated with emergency paid sick leave. This pay continuation requirement says if an employer sends an employee home from work due to COVID-19 exposure or possible exposure, regardless of whether that exposure happened inside or outside of the workplace, and the employee is not subject to a covered order of quarantine or isolation, the employer must pay the employee at their regular rate of pay. Now, this payment only stops, this continuation payment obligation only stops if the employer allows the employee to come back to work or the employee becomes subject to a mandatory or precautionary order of quarantine or isolation. Now, understanding this pay continuation sort of component is complicated. You need to coordinate it with emergency sick leave, with the guidance on quarantining and isolating, with the employer's own workplace policies and practices, and both emergency sick leave and the pay continuation component from this DOL guidance really hinge on this concept of an order of quarantine or isolation. So let's talk a little bit more about that. As you'll see on the next slide, there have been some updated guidance, both from the CDC in late December and then last month from the New York State Department of Health announcing that it's going to align its standards with the CDC's recent guidance on what circumstances trigger isolation, what circumstances trigger the quarantine for COVID-19. Well, the updated guidance says that if someone tests positive for COVID-19, regardless of whether they are vaccinated or unvaccinated, boosted or not boosted, isolate for 5 days, 5 calendar days. That is if you sort of think about this isolation for 5 calendar days, more often than not, the employee is likely going to be asymptomatic, right, or have symptoms that are resolved within 5 days. Now, if you have a moderate or severe case of COVID, then you can continue to isolate longer than the 5 calendar days. However, that 5 calendar day, assuming that you're asymptomatic or feeling better after the 5 days, once that 5 calendar day mark hits, presumably that order of isolation ends at that point. And that can bump into this at least 14 calendar days worth of emergency paid sick leave per order that I mentioned a few slides ago. And we'll talk in just a couple of slides about how to, at least theoretically reconcile that conflict. Also, as you'll see on the next slide, the state has also aligned itself with recent CDC guidance on when quarantining is proper. And essentially it boils down to your vaccination status. If an individual is not fully vaccinated or is eligible for a booster and not yet boosted, then they are required to quarantine for 5 calendar days after being exposed to someone who is confirmed or suspected of having COVID-19. Again, that 5 calendar day quarantine period, right, could now bump into that 14 days of emergency paid sick leave for employers with 100 or more employees. Next slide, please. So what does this all boil down to? For 2022 purposes, there are moving pieces, different standards, right? Guidance from the State Department of Labor, State Department of Health. Understanding what constitutes an order, right? What documentation can sort of trigger one of these orders of quarantine or isolation that would therefore trigger emergency paid sick leave and presumably, end pay continuation obligations. And also understanding this amount of leave that's required. Let's revisit that topic in just a second here too. So for documentation purposes, depending on the reason for use, there are different methods, different practical pieces of documentation, types of documentation, the documentation that can constitute proof of an order. The clearest one that's been around since the beginning of this mandate is that order of quarantine or isolation from the appropriate government entity, most commonly a local Department of Health. But there have been delays, there have been unresponsiveness, having to go from the employee who has been in close contact to the company, to the doctor, to the agency, back to the company or employer or doctor to get the order. That sort of game of telephone can take some time in practice. And the state has released guidance, and I saw a question come in on this, per the state's FAQs, if there are delays or lags with getting the order of quarantine from the appropriate or isolation from the appropriate government entity, then documentation from a healthcare provider attesting that the employee would qualify for such an order would generally be sufficient documentation. The Department of Labor guidance from January 2021 also says the documentation from a licensed medical provider or a testing facility attesting that the employee has in fact tested positive for COVID-19 is, and triggering an order of isolation is also considered sufficient documentation and is required. Most recently, and this is an important point for practical administration, the state has released this new self-affirmation option, these forms that employees can complete themselves, they don't have to be notarized, where they say, I attest that I am, subject to, that I am eligible for quarantining or isolating. And the forms have the full force and weight of an order of quarantine or isolation, per the actual language on the forms themselves. They're available on the New York State Department of Health website. Definitely worth taking a look, passing along to your benefits or HR teams, whoever is out there administering this program for your workers. Now, the amount of leave, a couple of final thoughts here before I pass this over. Number one, I saw a question come in on this. The orders, right, the 3-order maximum for emergency paid sick leave, that does not reset year over year. It's not a per year 3 orders of covered orders for emergency paid sick leave. That is sort of since the law began. So absences from prior years can be factored into 2022 entitlements and availability. With respect to that quarantine and isolation 5-day period of time, as I mentioned, the law itself for larger employers talks about providing 14 calendar days, up to at least 14 calendar days worth of emergency paid sick leave per order. But if an employee only needs to quarantine or isolate for 5 calendar days, that leaves open this question about what happens to the remaining 9 calendar days, or if the employee is out for 7 days or 10 days, what happens to the remaining calendar days? Do they get banked? Do they get kicked to the curb in a use it or lose it fashion? And that answer is an open question. Not completely clear here. I will say, though, that a combination of the Department of Labor's FAQs and their January 2021 guidance on the emergency paid sick leave with the 3-order maximum suggests that the use it or lose it option is reasonable. So if an employee only needs to quarantine for 5 or 7 or 10 days, or isolate for 5 or 7 or 10 days, and then the benefit sort of ends, right, or the order ends, that the employer would then, no longer need to pay the additional time. And because of the 3-order maximum and not having to go above and beyond that, you can sort of cut that 14 days, whatever is left over, push it to the side. Not completely clear, not a risk-free approach because it's based on non-binding guidance and it would be bumping up against the statute. However, that is a reasonable interpretation based on the materials that are out there. Okay, so with that, I'm going to pass this over to Michelle to walk us through the next New York State paid leave mandate, that is the COVID vaccine leave law.
Thanks, Josh. Next slide, please. As Marlon noted in the beginning of the presentation, New York State passed its COVID-19 vaccine leave law early last year in March. The law is set to expire at the end of this year on December 31st. The law applies the New York labor law's very broad definition of employer and employee, so it virtually applies to all employers and employees regardless of size. The amount of leave that employees are entitled to under the law is a sufficient amount of time not to exceed 4 hours per injection. So this means that employees will be entitled to up to 8 or 12 hours of leave, depending on whether they receive a single dose or double dose vaccine. I set up to 12 hours because in recent guidance, New York State clarified that vaccine leave is applicable to booster shots. So depending on whether an employee receives a booster shot, it can be up to 12 hours there. This is an important update to keep in mind. It's also important to note that the time employees are entitled to under the vaccine leave law is in addition to any other time the employer provides the employee, such as under New York State general paid sick leave law or any other leave provided by the employer or pursuant to a collective bargaining agreement. Also note that the law only covers time the employee spends getting vaccinated. It does not cover family member vaccination. In addition, unlike some other vaccine laws currently in effect, New York State's COVID-19 vaccine law does not cover absences for side effects. Bear in mind, though, that employees may still use New York State's general paid sick leave law for this purpose if they have that time available. While the law does not mention notice and documentation, the FAQs do provide that there's nothing preventing employers from having such requirements. Bear in mind, though, any confidentiality requirements when it comes to requesting proof of vaccination. Next slide, please. We're now going to move on from New York State and get into some more local laws. Next slide, please. The New York City Earned Safe and Sick Time Act originally went into effect on April 1st, 2014. So why are we still talking about it now in 2022? Well, it's been amended 3 times over now, in 2018, 2020, and most recently on December 23rd of last year. I'm going to now talk about some of these updates. As I said earlier with New York State's vaccine leave law, New York City applies those same New York labor law definitions of employer and employee, so it's pretty expensive, virtually applies to all employers and employees. The accrual rate under this law is same as the accrual rate under New York State's paid sick leave law. So again, that's 1 hour for every 30 hours worked. And here, both the accrual and usage cap are going to be 40 or 56 hours depending on employer size. So if the employer has fewer than 100 employees, it's going to be 40 hours, And if the employer has 100 or more employees, it's going to be a 56-hour cap. Just like under the New York State law, there is no usage waiting period for earned safe and sick time. So that means that the employee can begin using leave as soon as he earns it. Now, the New York City law provides that employers can carry over up to 40 or 56 hours of leave time to the following year, depending on employer size again. However, because New York State's paid sick leave law is more generous, and as Marlon earlier discussed, does not cap year-end carryover, we must follow the more generous state law, and New York City employers will have to permit unlimited carryover. Furloughding is also likely permitted under the New York City Earned Safe and Sick Time Act. While New York City does provide for a mechanism to avoid year-end carryover, previous slide, please. Thank you. While New York City does provide for a mechanism to avoid year-end carryover, under certain circumstances where the employer will front-load time, again, as Marlon mentioned, the New York State Department of Labor guidance regarding front-loading provided that employers must still permit carryover even if they are front-loading. So this is another situation where employers are going to have to follow the state law because it is more generous. Next slide, please. So earned safe and sick time can be used for numerous reasons. For example, employees can use it in connection with their own or a covered family member's illness, injury, health condition, medical diagnosis, care or treatment, or the need for preventive medical care. They can also use it for the safe time reasons listed there on the slide. But the New York City law goes a step further than New York State paid sick leave law because it also covers closure of the workplace, child, school, or child care provider due to a public health emergency. This is particularly relevant now during the pandemic. As Marlon mentioned, the city law also goes beyond the state law when it comes to covered family members. So in addition to all those family members covered by state law, child, spouse, etc., the city law includes very broad language that covers any other blood relative of the employee and anyone else who has a close association with the employee, the equivalent of a family relationship. So this is casting a very wide net here. As part of the December 2021 amendments, employees now get to use additional time, so in addition to the 40 or 56 hours, for child vaccine leave reasons, which Marlon is going to discuss shortly. Although this is not included in the law itself, in light of COVID-19, New York City released guidance giving examples of COVID-19 related reasons for which earned safe and sick time can be used. Some examples include taking time off when the employee is under a quarantine or self-isolating for preventive purposes, or time the employee spends testing for COVID-19. Next slide, please. Now, New York City has one of the most robust written policy requirements. They require a number of different things to be included in the policy, and while I'm not going to go through all of those right now, you can see them on the slide. There are things like the employer must put in the method for calculating sick time, so whether it's accrual or front loading, for example, the employer's carryover policy. And if the employer does have any written documentation or verification requirements, that must be in the employer's policy along with the consequences of not providing such documentation. Most importantly, all of this must be in a single writing, and the policy has to be provided to employees in a method that reasonably ensures personal receipt by the employee and consistent with any other applicable law regarding the method of delivery. With respect to when the policy has to be provided, there are going to be 3 times. So at the employee's commencement of employment, within 14 days of any amendments to the policy, and upon request by the employee. With that overview, I'm now going to turn it back over to Josh.
Great, thank you, Michelle. Next slide, please. So for just a very quick minute here, we're going to give folks an overview of enforcement of New York City Earned Safe and Sick Time. For those of you who are unaware, every year about the springtime, the city releases a State of Workers' Rights report. They've done it for 4 years in a row now. And the report from April 2021, when it was last released, is quite interesting. What you can see on this slide, really across the board in terms of complaints received, investigations opened, the amount of restitution collected, from employers found to have been in violation of the law, and the scope of administrative penalties collected from employers. All of those numbers are down, right, from 2017 to 2019 versus 2020. Now, clearly, COVID had a major impact on all industries, entities, individuals. So it's not surprising, I think, to see the dip in these numbers. What is surprising a bit is that New York City has historically been one of the most aggressively enforced and actively enforced paid sick leave laws around the country. We are expecting to see a big uptick in these numbers, more aligned with 2018 and 2019, when the 2022 report is released and has the 2021 data. So be on the lookout for a Seyfarth client alert about these updates. So we did want to pass this along to folks to let them know that this is available. It's released by the New York Department of Consumer and Worker Protection, the New York City Department of Worker and Consumer Protection, and it has some really good content in it, so worth taking a look at. Next slide, please. Also, on this next slide, you will see that the report also includes information on the nature of complaints that have been received from the agency, from employees throughout that particular year. The topics that are most commonly, the most prevalent: you didn't pay me for sick leave, you didn't provide me with sufficient notice, you failed to maintain an adequate written policy, as Michelle and Marlon both mentioned. And you can see that in 2020, for the first time, the failure to maintain a written policy was the #1 most common complaint received for New York paid sick leave alleged violations. Unlawful retaliation, another big one. At the very bottom of this slide, unlawful interference, right? That is, of all the topics listed here, the only topic that did not have a sizable dip between 2019 and 2020. And that shows that the agency is really honing in on potential unlawful interference. You've chilled the employees' rights because managers didn't provide the right notice, or made them feel like they couldn't take the time off without repercussions, or you forced them to use it when you might not have been able to actually mandate and force the use, and so forth. So pay attention to unlawful interference concepts within your policies and your practices. We're happy to provide guidance there. Next slide, please. And I'm going to pass this over to Marlon to round out our New York City child vaccine leave updates.
Thank you, Josh. Just before I do that, I want to give you your CLE code. It is SS, as in Seyfarth Shaw, 7366. So again, SS, as in Seyfarth Shaw, 7366. And with that, I'll go on to the next slide and discuss the New York City Child Vaccine Leave Law. So this went into effect on December 23rd, 2021, with a retroactive effect to November 2nd, 2021. What's important to note here is that this is not a separate law, but it is an amendment to the New York City Earned Safe and Sick Time Act. Under this amendment, employees receive 4 hours of COVID-19 child vaccination time per vaccine injection per each child, and this time is in addition to any time provided already under the New York City ESTA. The important thing to note here is that there is no maximum amount of time because it varies based on how many children the employee has and whether they're eligible for the vaccine. The employee can use the leave in connection with their child who's under the age of 18, or an older child who is incapable of self-care because of a mental or physical disability. The employee can use the leave to take these children to receive their vaccine shot, or to care for the child who's experiencing temporary side effects from a COVID-19 vaccine injection. The rate of pay here is the employee's regular rate of pay. Next slide, we're going to see the notice requirements. Basically, an employee can require reasonable notice of the need to use vaccination time and can require reasonable documentation within 7 days of the employee's use of COVID-19 child vaccination time. Whether you can request it for the retroactive use is a tricky topic, so that's something to be mindful of. In terms of written policy requirements, although not completely clear, most likely you would have to have a written policy requirement because it is an amendment to ESTA, and as Michelle mentioned, there's a whole laundry list of written policy requirements. It's also unclear if there is an available balance notification or a notice posting requirement, and there are a number of things to consider when making a determination of whether you need to do that. With notice and posting, we are hopeful that we will have some more guidance to address these open issues. And with that, I will turn it over to Josh to finish us up.
Great. Thanks, Marlon. Next slide, please. So, folks, we want to pass along just a couple of Seyfarth paid leave resources for you all to be aware of. Also, for anyone who has a few extra minutes, we're happy to stay on for 5 minutes or so beyond the top of the hour. I've seen a lot of good questions come in, so we'll try to knock out one or two more of those to the extent we haven't gotten through them. And if you do have additional questions that we didn't get to, please do feel free to reach out to us. Our contact info was included on one of those first few slides. So number one, we have a great paid sick leave survey, comprehensive, covers all COVID, non-COVID, state and local paid sick leave laws. You can get more information at paidleave@seyfarth.com. We also have a paid leave mailing list. All of our legal updates and client alerts will be made available to you. So all you have to do is sign up. It takes less than a minute. The link is right there for you. Next slide, please. Another great resource is the webinar series, our guidance on paid sick leave webinar series. This is part 6. You can see the list of topics we've covered in parts 1 through 5 there as well. We'll be having part 7 coming out over the next month and a half or so, where we're going to be doing a revamp of part 3, which will be focusing on COVID-19 supplemental and vaccine paid leave mandates around the country. We also have a webinar series on paid family leave, just as complicated and as much fun as paid sick leave. So be on the lookout for the next segment of that series coming shortly. And then finally, we have started a Take It or Leave It podcast. That was started back in December, so just a couple of months ago. We've launched 4 episodes so far. We've covered accommodations, religious and medical related to the COVID vaccine, federal paid family medical leave prospects, and our episode that dropped just a couple of days ago covers remote workers and leave and accommodations considerations, remote and hybrid worker considerations. All episodes are available and streaming on Spotify, SoundCloud, Apple Podcasts, and Seyfarth's website. We've got a link there if you want more information. Great to listen to during your commutes, lunch breaks, and the like, to put you to bed at night as well. So definitely worth taking a listen. I co-host that podcast with one of our great colleagues, Meg Toth. So thank you, everyone, again for attending. Like I said, we're going to spend just a couple of minutes going over some of the questions that came in, go another few minutes here, and then we'll drop off for the day. Thanks again for the folks who sent in the questions. Thanks for attending. Thank you for the feedback. So a couple of things in no sort of particular order here. So we've seen a few folks sort of raise questions about PTO, paid sick leave. Can you require employees to use PTO or vacation time for emergency paid sick leave under the New York State law? The short answer is no. The law talks about not being able to sort of run, count other accruals, paid sick leave accruals, paid time off accruals, for compliance with the emergency paid sick leave requirement. So even though you might have a really robust PTO program, 15 days, 20 days, 25 days of PTO, technically the emergency paid sick leave is above and beyond that benefit. Now, a related question that came in, and this is a really good one, and Marlon and Michelle and I are happy to chat offline with anyone because there are so many more details and nuances, industry specific, employer specific, nature of your workers specific, risk tolerance levels, all the fun things, potential penalties. But there's a question about if I already offer employees a company provided COVID paid leave, can I count that against your New York emergency paid sick leave entitlement? And that's a gray area, frankly. But the sort of the more conservative, safer reading is that the answer is no to that. That because that time, even if the 80 hours are provided in sort of an upfront, front-loaded grant, they're just available for this reason, they could still be considered an accrual, right? And like I said a minute ago, accruals can't be used for purposes of compliance with this mandate. There's also a risk where if the employer provides this company, COVID paid leave that is available for other reasons, above and beyond the New York State emergency sick leave, that one reason, and subject to an order of quarantine or isolation due to COVID, I use my time to care for a family member because my kid's school is closed. That wouldn't count. That would not be able to be used to sort of offset your New York entitlement and obligations there as an employer. All right, let's keep moving through here. So that was concurrent use. Saw quite a few of those. Let's see. All right, so Marlon, for this one, there's a question here to confirm about New York State paid sick leave. To confirm, even with carryover and front loading, employees are still limited to taking 56 hours of paid sick leave per year, regardless of if they have additional hours in their carryover bank. Is that correct?
Right. So even regardless of carryover balances or what the employee has accrued or has been granted by way of front loading, you can still cap usage in a year to 56 hours.
Yep, exactly. Thanks, Marlon. So a question in here, shout out to folks tuning in from Massachusetts today. Hope you all didn't get as much snow as we got in New York. I'm still digging out parts of my driveway. The Massachusetts emergency paid sick leave law, right, for those of you who are paying attention there, that benefit is around either until April 1st or until the state runs out of funding. It's a little bit different setup than New York. There's a $75 million sort of funding pool. It's kind of similar to the paid family medical leave laws around the country. I haven't heard anything crystal clear, but I do not believe they are anywhere close to the $75 million cap for Massachusetts emergency sick leave. So I would expect that one's going to be with us at least until April 1st, and it will perhaps get extended even further. So more to come there. Let's see. We had a question come in about rates of pay, right? Regular rate of pay. That's kind of recommendation for determining your regular rate of pay options. The laws don't give a lot of guidance on the true meaning of that phrase and term, but generally speaking, following the FLSA standards for calculating the regular rate of pay, the weighted average calculation concept, the forms of compensation that need to be built in there, those are sort of the best practices with respect to New York, where there is a regular rate of pay obligation. Let's see. It was just a couple of more, and then we'll drop for the day here. So, does New York State COVID paid sick leave need to be reflected on wage statements? That's a really good question. I don't believe so offhand. There's an obligation under the state law, non-COVID law, that is, to respond, to provide information to employees when they request it. There's an obligation under the New York City or State and Sick Time Act to provide balance notification each pay period, either on pay stubs or company intranet, things like that. Nothing specific about emergency paid sick leave, though, so that's sort of an open question with respect to the laws needing additional analysis there. All right. Someone asked, do we mind reiterating if employees now have to be paid out for unused sick time in New York City? They do not. Right, Marlon, there's no obligation to pay out New York City earned sick leave a year, and they can still carry over. Is that right?
Correct. And the same thing both under state and city. No need to pay it out.
Perfect. All right. Let's see. Do one more. Is there a credit that employers can receive for having to pay out the emergency COVID sick leave? Not in New York. So apologies if I confused anyone there. That is only for the Massachusetts sick leave law. So no obligation or available credit for purposes of emergency sick leave in New York. I see a question about why carryover would ever be required to the extent you front load the first 56 hours to workers at the start of the year? And I say that is a good question, and I recommend complaining to your local state legislature about that, because it is one that bugs us also. I'm happy to talk that one through for anyone who has more questions. All righty, thank you so much. Just next slide for us. Thank you everyone who stayed with us for this extra little Q&A. If you have other questions, again, please don't hesitate to reach out. We have a great bench of attorneys, New York State and across the country, that focus on these paid leave issues that are giving so many employers headaches. So thanks for attending. We look forward to seeing you at our next webinar. Thanks so much, everyone. Be well.